Okay, let's get your reaction as the Constitutional Court has delivered its judgment on the much-anticipated case that was brought up before it by independent candidates as well as One South Africa. And we are now joined by independent candidates Zackie Achmat and Terry Tselane from the Institute of Election Management Services in Africa to take a look at how this judgment will impact elections next year and independent candidates and their participation. Thank you very much, gentlemen, for your time this afternoon. Mr. Achmat, let's start with you. No doubt you're breathing a sigh of relief because Justice Colopin found that the 15% quota must be replaced with 1,000 signatures. So essentially, on the signature requirement, the majority of judges upholding your challenge, but the majority dismissing the recalculation challenge. How are you feeling?
Well, perhaps the place to start is to say that the Constitution is supreme in the country. And while I disagree with the recalculation decision, because from experience, I understand that there wasn't sufficient evidence before the court, and therefore the court made the decision that it made. No matter how much disappointment I have to abide by the Constitution, so the Constitutional Court's judgment, and therefore I'm happy with that. But I'm elated that I'm on the ballot, that you can now vote for me if you're in the Western Cape. So I'm going to ask you to move to the Western Cape so you can vote for me. It's a critical step forward because what most people don't understand is that the majority of people in our country are tired of party politics, and this opens the door for a change. It's not a panacea because you can have progressive candidates and you can have regressive candidates, but it opens the door to progressive candidates in every province. The recalculation, the question of the compensatory seats, the 350-50, that we can address in the next parliament and must address.
Mr. Tselane, sir, just remind us of what the IEC had said in terms of this application and what this judgment then means for the IEC. They were worried about the ballot paper.
Thank you very much for having me. You remember that the Electoral Commission had indicated that it would actually abide by the decision of the court. So they will definitely implement the decision of the court in its totality. One area that the judgment was on the 200 split of seats. That, as you know, has been dismissed, and therefore there is no need for the Commission to revise its system to try to deal with that particular aspect. The only area that would obviously require the Commission just to relook, and I don't think it's going to be a lot of a problem for the Commission to deal with it, is on the issue of the requirements for the candidate to participate in the elections. At first it was 15%, and now that 15% has actually been now removed by the Constitutional Court judgment. And so the requirement for a candidate to participate in elections is similar to what it would have required for a political party to participate in the election, which is 1,000 number of signatures of registered voters.
What of the issue of overhang? Because we heard from Justice Mhlandla saying that the applicant hasn't represented a viable remedy, Mr. Tselane, should an overhang occur with the 350-350 split, saying the consequences, 350-50 split rather, saying the consequences are severe as explained by the IEC, saying that the respondents submitted that the 350-50 split would also lead to proportionality. She says the choice of electoral system is left in the hands of Parliament.
Of course, that was yes, it was an important aspect because what the Atkins report indicated was that possibilities of excessive seats, what they call overhang, was very high in the case where the split is between 350 seats to 50. And therefore that the current arrangement of 200 to 200 does not actually have a risk of having what we refer to as excessive seats or alternatively overhang, as the Constitutional Court has indicated. So it means that if the 350, if the Constitutional Court had changed that arrangement, or the Constitutional Court indicated that it does not in any case have the powers to do that, that power is with Parliament of actually making a decision in terms of whether it is 350 or 50. But evidence that has been presented through that Atkins report clearly indicates that the 200 to 200 is much better because the elements of risks are lessened than in the case of 350 to 50 split.
Mr. Achmat, the Chief Justice on the 15% signature requirement found that it does not detrimentally affect anyone's right. He's of the understanding that independent candidates must go out there and do what they were going to do anyway, and that is to convince the electorate to vote for them. As we heard, Justice Colopin came to a different conclusion. And so when we take a look at this, what does it now say in terms of your participation practically? Maybe explain that to our viewers in the election. And should you be chosen, what happens after that? Or should you meet the requirements to then move to the next phase? What does that mean? Please explain that to our viewers.
My reading of this and my experience and the campaign experience, I've had to put hundreds of volunteers onto the streets to get the more than 13,000 signatures that we've now collected. And if you're collecting 13,000, you must speak to at least 10 times or 5 times the amount more to try and convince people. The amount of money spent on that is close to 700,000 rand, and that is unjust. It is easier to spend that money on convincing people to vote for you rather than asking people to recognize your right to stand on a ballot, because I got signatures from people who wanted to vote for the ANC, who wanted to vote for the DA, but to recognize the fact that I have a right to stand. So the 15,000 signature, I could reach it, A, because I'm known, very widely known in the province, and secondly, that I am associated with a large number of movements on whose activists I could draw. However, a poor working class candidate who is a farm worker in, let's say, the Winelands district, and she is very popular, she's done great work in the community, she won't be able to afford that. So it's an unjust measure in that way too. Having said that, I think the greatest injustice is the fact that the whole province becomes our constituency as independents. What would have been better is clearly demarcated smaller constituencies that is multiple candidates and retains proportionality. But I'm sure that we can convince Parliament in the new Parliament, especially because I'm going to be there and you're going to help me, not you as the media, but certainly I hope that voters will help me get there. So yes, I'm delighted that I'm on the ballot as I speak informally. I just have to hand over my signatures to the IEC, upload it to its system. I'm delighted with that, but I'm disappointed that I've had to spend so much money, and the apparatus that an independent candidate has to build has to be province-wide rather than simply in a contained constituency.
Mr. Tselane, sir, we heard from Justice Colopin saying that elections are not just about arithmetic. They're not just about winners and losers. They serve value, which speaks to democracy or aids democracy in the country. Given that the recalculation application was dismissed by the majority and it was cited that OSA relied on foreign legislation, what does this say about democracy in South Africa? More so when you take a look now at the ballot paper, because it is not all South Africans who are on the same page about whether this assists democracy or not.
I think what the Constitutional Court was doing there was to basically emphasize the rights as contained within Section 19 of the Constitution. But I also wanted to come back to the issue that we were raising earlier on, because sometimes people don't understand when we talk about the issues of overhang or excessive seats, what does it mean? And I want to explain it in very simple terms. That particular aspect refers to a situation where in Parliament, the Constitution says you've got to have at least between 350 and 400. Now, if you've got 400 members who should actually be in that Parliament, but the quota that you are using provides you with more people than the number of available seats, that's where the problem is, because now you've got more people who qualify to be in Parliament using the system that we were using. And now you've got to try to deal with how do you get rid of people who have qualified to go into Parliament. That's what is called overhang or excessive seats. You cannot have more than 400 or more than available seats in Parliament. So going back to the issue that we are raising, the emphasis, I think, is largely on the issue of having to entrench the rights of individuals, firstly to stand for office, and also to try to contest and stand for office, and also to for the voters to be able to exercise that right of electing whoever they want to elect without any serious barriers.
Thank you very much, gentlemen, for your contribution this afternoon. Independent candidate Zackie Achmat and Terry Tselane from the Institute of Election Management Services in Africa.